All right. Hello, everyone. I hope everyone is well situated and had a good week. We're going to go ahead and get started with our live stream. Looks like everything is good to go. I am Ernie Garcia, and I welcome those of you who are joining us here on the live stream. We are talking today about locks and changing locks. I've got a couple of other important announcements that I want to share with everybody as there have been some updates to state law, and we're coming up on a holiday weekend, and we got all sorts of cool things going on. In fact, we got a live event that I want to talk about that I've talked about before, and I want to share a little bit about that with you today. I'm going to run that along the bottom. We are having a workshop here in Houston, or in the Houston area. It's technically in Pearland. And we are going to have that workshop in Pearland where I'm going to assist landlords and teach you guys live in this workshop this Friday. So it's in 2 days. There's a few spots left, not many. The last time we checked, there were only 5. I think there's still a couple left. But if you are interested in coming, it's a workshop we're hosting in Pearland. For those of you who are interested, I would really love to see you there. We're really hoping that we can get a lot of people out there. Again, I'll be there live showing you all the steps you need in order to write an effective notice, how to send these notices, when to send these kinds of notices. And as a bonus, I'm going to show you ahead of time what the changes in state law now require of new notices. There is a new thing that'll start January 1st in the state of Texas called, and we get a drum roll, it's called a notice to pay rent or vacate, and it's got some specific rules that work with it. I'm going to go all over that in that live event, but also for those of you who are interested, I'm going to do a full-length video on all of the legislative changes that have or that will take effect September 1st, and all those that will take effect January 1st of 2026. I've got a full-length video coming out this coming Monday, so September 1st, 2025, a full-length video all about these legislative updates. So if you can make it to our event on Friday, I would love to meet you and talk to you in person. If you cannot, but are still interested in checking out those legislative changes and what I have to say about them and how they work and how they're going to affect landlords, check that video out on Friday. I hope you are able to see that and are able to really benefit from everything that that these changes are going to bring to the table. So today's topic has all about changing locks, and sometimes landlords are a little confused about when locks need to be changed, who covers the cost, what's in place. And I'm going to say this because, our stream goes out all over the place. If you're in the state of Texas, I'm going to speak Texas law specifically, but you might be in some other jurisdiction. And so like I always tell landlords, look, you got to go with what's applicable in your jurisdiction. If your jurisdiction doesn't require this, I actually do recommend it because the state of Texas does, and I'm going to get into those requirements. But if your jurisdiction doesn't require you to change locks, it's just a good idea to do it because you want to keep your property safe from unscrupulous people who may have had access to that key. And you also want to keep your tenant safe. Nobody wants to live in some place where they feel like, they're under some kind of threat. Hello, James. I see you chimed in there. By the way, for those of you, I've got questions here. For those of you who have not submitted a question either through our newsletter or on our Facebook group at TexasLandlords.com. It's not .com necessarily, but Texas Landlords, the Facebook group on Facebook. If you've got a question here live on the chat, just add it to the chat, and I'll do my best to get an answer to you based on when those are received. So I look forward to answering those questions. I've got a set of questions here, but I want to continue with the issue of security locks and what the state requires. So if your jurisdiction doesn't require you to change them, probably still a good idea. It's a good habit to have for safety of your property as well as the safety of your tenants. But here's what the state law says in Texas. This is right out of chapter 92.156, rekeying or change of security devices. And here's what the code says. It says a security device operated by key, card, or combination shall be rekeyed by the landlord at the landlord's expense, not later than the 7th day after the tenant turnover date. In other words, once your tenant's gone within 7 days, you got to rekey that. Essentially, they call it a security device because it's technically different depending on the kind of device that's being used. But yes, you've got to rekey within 7 days after the prior tenant moves. Now, you might have multiple doors with the same lock or multiple locks. I would get everything on one uniform system, but every time your tenant moves, that lock has to be changed. Now, you may be thinking, well, Ernie, I thought that if a tenant was in default when they leave, or if they breach the lease, I don't have to change it or I don't have to pay. Which is it? It's you don't have to pay if your lease clearly, and state law requires that you put it in underlined or bold print, clearly you establish for your outgoing tenant who left in breach that by leaving in breach, they are subject to the cost to rekey the property as you quickly get a new tenant. Otherwise, it's always on the landlord. Rekey it within 7 days, and make sure you're following these rules. I'll be honest that I haven't had a whole lot of incidences where a landlord has been called to task for not changing the locks. But the last thing you need is to have someone break in, that it be determined that they entered with a key that you failed to change. And therefore, now you, where you otherwise wouldn't have liability for the criminal acts of third parties, now you may have liability because you failed to follow the code and failed to deliver a safe habitat to your tenants. And, stolen stuff is one thing, but injured people would be truly, truly terrible. So, prevent yourself from that kind of liability. Follow what the code says. If you can charge it to an outgoing tenant who is in breach and from a lease where you have clearly indicated that they will be subject to these costs, absolutely pull that out of the security deposit, but do it quick. Within 7 days of them leaving, change those locks. And then, of course, if someone leaves on the regular course, once they're done, you assume the cost to change those locks. Now, if you've got keypads, all you really got to do is change the code. You don't have to change the entire system. Let's see what James contributes here. I use Quickset smart locks. Easy to rekey and cost effective. I've heard of landlords doing that. That is an excellent alternative where you're just switching out parts, and so a previous lock is ineffective. After the initial investment in the locks, of course. Well, yes, it's going to be a little pricier. And so some landlords are going to keyless entry where it's all digital and all you have to do is change the combination. That's another alternative. Just make sure you're not repeating combinations that are easy for you to remember. I certainly wouldn't reuse an old combination from a prior tenant. Make sure each one is brand new. So that's what the law says about changing locks, and that's the requirement that the law makes of all of you whenever you're in a situation when a prior tenant has vacated. If your jurisdiction or if your jurisdiction has a stronger policy, if you're outside of the state of Texas, again, I'm speaking from a Texas perspective, if your jurisdiction has a stronger policy, certainly you want to be made aware of that, and you want to be following whatever that particular requirement is. So we want to go ahead and go now to our regular questions. And, I want to get into these prefab questions that I've received. If you've got a question for me that you would like to share in the chat, go ahead and add it below. In fact, let me see. I'm supposed to add something real quick. For those of you who missed it, we do have a live event, and I'm going to talk about it a couple of times for sure. For those of you who missed it, we do have a live event coming up, and so I want to make sure that everybody gets a chance to check that out. I've just posted it in the comments. There's a link to that event. I'm going to show you again what we've got here with that event. It's a notices workshop. In fact, I'm going to jump down to Chuck Pace's question. This is number 3. Chuck, if you're there, hi, thanks for this question. It's a great question. And it's actually the focal point of this Friday's workshop. Chuck asks, can you talk about the coming changes to the property code that we need to be aware of? So along with, I said it's the focal point, it's one of the things we're going to talk about at the workshop. But one of the big changes that has occurred is the way that notices are delivered and the kinds of notice that must be delivered. We now have what I'm calling the one chance rule. And what this says is the law now requires that, whereas before you didn't have to give your tenant an opportunity to pay, now the law requires it with your notice to vacate. But it's under a very specific guideline. If the tenant was current in the previous month, but they are not current in the current month, and you issue a notice to vacate, that notice to vacate as of January 1st, 2026, must allow them to pay the rent. So if you send a 3-day notice, it has to be a, quote, notice to pay rent or vacate, so that if they pay the rent within the 3 days, you cannot evict them. Well, Ernie, what if they do this every subsequent month? Well, that's a great question, and the code talks about it. It doesn't apply after the second month. If the second month they do it again, well, you're no longer required to give them an out. They must vacate if you issue a notice to vacate. But if you continue to issue a notice to pay rent or vacate, then you always give them that option, and it appears that if they do pay, you're stuck with them because that's what your notice says. So it's important to know that the property code as of January 1st, 2026 will require this small change in notice, but it's also important to know that you don't have to use it exclusively. It's one time if the situation calls for it, and if not, you're no longer required to use it. So I'm going to teach you all about that difference this Friday, teach you how to draft it. And another key change that's coming is, guess what? As of January 1st, 2026, if your lease allows notice by email in the state of Texas, you can begin January 1st, 2026, sending your notice to vacate by email. You can also send it through FedEx. You can send it through UPS. There's all sorts of updates to the way notices can be delivered. We're going to talk about that at this notice workshop. These changes don't take effect until January 1st of 2026, but it's important to start getting ready for that now. If you have questions about this workshop, I welcome you to come check it out. I'm going to leave this ticker here. If you look at the comments below. I've got a link there that you can click on to check out later information about this workshop. Again, we have a few seats available. If you're able to make it, I welcome you to come to that. Chuck, thank you very much for your question. I can talk about changes in the law. And for those of you who are interested in seeing more about the changes of the law, Monday morning, that's Labor Day at 8 a.m., I'm going to release on this YouTube channel an in-depth look at all of the legislative updates. I welcome you to check that out. Let's get back to the questions now. Morris Porter, if a tenant appeals an eviction judgment by a JP court and later moves out before the county court renders a judgment, so JP court appeal, moves up to county, but moves out in between, no judgment out of the county court, does the tenant have to continue paying into the court registry until the judgment is entered? So the tenant is never absolutely required to pay. The tenant is required to pay if and only if they plan to stick around. And so, failure to stay or failure to pay means you can't stay. And so if they do leave, they still owe you the money. In fact, they may owe you more than the court is willing to award you, because a court can award things like late fees or damages or unpaid HOA or other things that would apply based on your contract. Can the court continue to force them to pay? No. Their payment is what allows them to stay during the pendency of the appeal. Do they still owe you that money? Yes, very likely they continue to owe that money, and probably a lot more. So let's go on. Monica Gertz writes, how does one handle an issue of a tenant violating city rules, such as junk vehicles or trash in the yard, furniture outside, even if the landlord has already advised them to clean it up? I don't exactly know what you mean here by the landlord has already advised them. I'm hoping what you're saying is the landlord has already issued multiple notices of default, because if all you're doing is talking to your tenants, that's just not as enforceable as issuing a notice of default. I strongly recommend that if your tenant is in fact in default, that you're issuing these notices. And so what you've got to ask yourself is, does your lease even mention HOA rules? Does it mention city or county laws that the tenant is required to follow? I'll tell you this, if you've got only an oral lease agreement, none of this applies. And it doesn't matter how many times you've mentioned this, they're not subject to these terms if your agreement is purely an oral agreement. So, yeah, I mean, I hate to be the share of bad news, but you just don't get that option when you don't have anything in writing. But if your written lease does require them to follow these rules, you've got default when they fail to follow. And it's incumbent on you to issue notice and then hold them to it. I preach a 3 strikes and you're out rule. And so if you're not practicing that, you got to start it. It's part of basic lease enforcement. Issue the notice of default and enforce that rule. So let's go on to question number 4. Kimberly Johnson writes, because we already did Chuck's question, we just kind of did these in reverse. Can you answer a question on mechanics liens on homestead property, or know anyone who can? I can do both. But essentially, I guess your question is, can a mechanics lien be exercised against someone's homestead property? Yes. And so a lien that you have against property that is otherwise a valid lien can be exercised against you, and you The problem with mechanics liens, and this happens a lot, is there's probably an error in the lien, or there's a pretty high likelihood that there is some error in the lien. Sometimes you get, people who do work on property or who do work for property, put in all these liens and they don't know what they're doing. They assess these liens and they're just not enforceable. They either didn't do it right, they didn't give a proper notice, and so when they try to exercise them, they really just create a mess. And unfortunately, I have spent time removing bad liens from homeowners, but understand, if you've got a lien, you might be subject to foreclosure, and you're going to want to take that seriously. Go and find a real estate attorney that you can talk to review that with, to make sure you're not at risk of losing real property. So I hope that helps. Let's move on to Diane's question. But first, let's see. Robert Arroyo writes, first time I heard you're talking directly. Thank you very much for the advice. Thank you. You always give us. Oh, wow, Robert, you're very welcome. Again, there's a link right here up above your comment if you are interested in seeing me live and in person. We're hosting that event on Friday. More information is there for you to check out. So I'm glad you're enjoying this, and I enjoy doing these. I think it's helpful, and I think clients get a lot out of it, and so I'm going to keep doing them. People seem to enjoy them. So let's continue. Yeah. By the way, if you need to book a consultation and speak to one of the attorneys we have here on staff, don't hesitate to give us a call. If you're in the state of Texas, if you're outside of the state of Texas, I can't really help a whole lot. But if you are in Texas, feel free to shoot us an email or give us a call. We're happy to help any way that we can. But let's go on to Diane's question. She writes from our newsletter, my tenant sent email stating that she's already moved due to medical reasons. She didn't give a 30-day notice as required, did not provide any medical documentation in advance or after. She requested her deposit back. I read on disability rights site, medical reasons can end a lease. Can I keep her deposit to pay September's rent and take her to small claims court for any other damages deposit doesn't cover? What about the reletting fee? If she provides medical documentation after the fact, does that change circumstances? Also, the lease states utilities must be kept on until the lease ends. She shut them off. If I turn them back on to keep the house from heat damage and the bill comes 45 days more later without a new tenant, tough market right now, how long can I bill after the fact? Do I take her to small claims court if the deposit doesn't cover damages, early termination fees, and is there a time frame to collect? Well, there's a lot of questions there. I want to take it piece by piece. I want to start first with the last question. What is the time frame to either collect it or to file a lawsuit? In the state of Texas, and this is true across most states, you've got a 4-year statute of limitations, which means from the date of breach of your contract, you've got 4 years to bring that claim to the court. If you do not bring your claim within that 4-year time frame, you probably can't raise your claim and it is dead. Now, I don't recommend waiting 4 years before you bring your claim. That isn't particularly helpful. All sorts of trouble comes from waiting too long. But if you've got a claim, I would raise it within the first 6 months. Within the first year, still okay, but you don't want evidence to get ruined or witnesses to get lost. And you certainly want to keep track of whoever it is you're trying to sue, which is my next point. You're really eager to go after this person, but I always ask landlords these 2 questions whenever they want to sue. Number 1, can you even find them? Because if you can't locate an individual, you can't sue them. You have to be able to personally deliver that notice to them. In very rare occasions, the court will allow you to do other kinds of notice, but it's not very likely. And you may be asking, well, what about all those times when the eviction court just sends them the notice through the mail or posts the notice on the door? Yeah, that's an option for an eviction because there's a reasonable expectation that the individual lives there. That same option doesn't exist in a regular civil claim. So you can't really rely on that as a possibility. So if you can't find them, you can't sue them. And secondly, let's say you can find them and you do sue them. You sue them for a gajillion dollars, but they have nothing. You know, suing people who have no money or no capability of paying you is just a big waste of time. I don't recommend it. And so even though, you know, I might shy away from doing work from someone who's very eager to sue, you know, I'm going to recommend if the people that you want to sue just don't have the capacity to pay, it's just not worth it. So I don't recommend it. So let's get back to the issue at hand, which I think is the question about, can a medical issue be used as the basis to terminate a lease? And the short answer is yes, it can be used. And so the question is, why would a landlord have to terminate somebody's lease when some medical issue just pops out of nowhere? Well, it might be because someone has a legitimate disability and they give you notice and make a request for a reasonable accommodation. And so the law does allow an individual to make this kind of request. And if that kind of request is made and you deny it, you could have a whole bunch of trouble coming after you for a federal claim under the Fair Housing Act. You may have broken the law. But in this set of facts, I don't know that that's really present. So she didn't give a 30-day notice. She moved out due to medical reasons, but I'm not sure when she requested the early termination. It almost doesn't even sound like she did. So depending on the severity of the medical issue, is it possible for someone very quickly to say, hey, I gotta go. I am deathly ill and I need treatment that is only available in New Hampshire. And so I'm out, sorry, gotta go. Is it mathematically possible that that situation called for emergency procedures that were only available out of state? Yes, that's mathematically possible. Is that the case here? Couldn't tell you. I don't have enough facts here. But I also wouldn't be super cavalier with the facts and say, well, I get to keep all of the deposit, because clearly there's no way she had a legitimate medical issue that would allow her to terminate the lease. I still don't know enough to tell you yes or no on that issue, but I would be cautious. And so if you have another basis, maybe there's damage to the property or unpaid rent or some other basis for deducting the security deposit, I would use that. But it does seem like you may have gotten some medical information. I would review this with an attorney to make sure you're not in a predicament where she's got a plausible, if not a strong claim for a reasonable accommodation under the Fair Housing Act. If that's the case, you might end up having to return that deposit. Again, these are very case specific. It's going to matter when you got notice. It's going to matter what kind of medical condition she had. But I can't say with absolute certainty that this is a no. For now, it's unfortunately a maybe. So, all right, James jumps in. Does someone have to make the request in writing before you take action? It seems like that would be a reasonable thing for the law to require, but the answer is no. They are not required to give you notice in writing. They just have to prove that they gave you notice. And so that could be even just their oral statement, that you had some access to the knowledge that they had this medical condition, and that makes the basis for their request, which again, need not be in writing. But if they make a request for a reasonable accommodation, you have to have a good reason to deny it. In other words, the accommodation itself has to be unreasonable. Let me give you an easy one. let's say someone is in a wheelchair and this happens during the lease. They came in just fine, able to walk, but during the lease, they suffered some accident that renders them in need of a wheelchair. And they have assistance, and it's possible to get up to the front door, but man, would it be helpful if there was a ramp up to the front door. So is it reasonable for the tenant to require you to pay for that ramp? The law actually says no, but it is reasonable for the tenant to say, look, I'll cover the cost of the ramp. I'll even cover the cost to remove the ramp. May I put it on? At that point, it's going to be very difficult for you to say it is reasonable to deny that accommodation. Let's say instead you have a very wealthy tenant and they say, I would like to pay to install an elevator on the property. Could you reasonably deny that request because of the harm that would come to your property? I think you could. And so a ramp probably wouldn't affect the structure of your property, whereas an elevator, even if they could pay to install it and remove it, that would be a major reconstruction that I don't think you are required to accept, right? So is the request reasonable? Is it not? Are they reasonable in what they're willing to offer in order to get that accommodation? That accommodation, all these are very specific issues that you'll want to refer to counsel to review. James writes, a landlord is not required to anticipate accommodations before they are made. Correct? That is correct. Just because you suspect, they have to have made the request. Again, doesn't have to be in writing, but they have to have made the request. Ilda Kokmik says, how should a property manager handle a tenant demanding the owner's contact info, despite the lease stating the manager is the point of contact and even threatening legal action if contacted for, and then it cuts off. Let me explain something, because this is a change in Texas law that shocks a lot of landlords. The tenants are entitled to that information. If they make a request and in that request say, by the way, if you fail to give me this, I've got rights under the property code that allow me to terminate my lease if you don't get it to me within 7 days. You are required to disclose, if it's not in the lease already, who the actual owner is, and you're required to give contact information, which would be a mailing address to reach that owner. And so the fact that you don't feel comfortable doing that is not enough. State law does require it. If I had a little time, I would go and I would find the specific code provision, but state law does require this. And you want to make sure that you're in line with state law. You don't want to have to explain to your property owner why the tenant, who is a good tenant, took off in the middle of the lease, and now you can't go after them for any damages. She goes on and says, a tenant is even threatening to sue me for harassment to get a restraining order if I contact her for anything related to the lease. How does that work? Now, that's a different argument. So they're asking for the owner's information. I guess they want to deal directly with the owner. And again, technically they're entitled to the owner's contact information, but they can't say, oh, and I don't want to deal with you. That's just not allowed, because you, as the agent for the owner, effectively are the owner. And so that's not something they can demand, but they can demand contact information for the owner. Typically, regular notices having to do with the lease or regular contact subject to the lease is not harassment. So I don't know exactly what's going on, but typically when you got a tenant like this, I got to have more facts, because sure, it would be harassment if you show up to the house with a bullhorn and you're constantly yelling, and you show up at 5 a.m, that sort of thing. That might constitute harassment, but regular communication, like most humans do, generally isn't, even though they say, I don't want to talk to you. They don't technically have that right because they're subject to the terms of the lease. So James says, can a mailing address for the owner be a P.O. box? Yes, it absolutely can. It just has to be a mailing address. It doesn't have to be their residence or their place of business. The owner is an LLC. Now it gets a little complicated because a contact for an owner can be a P.O. box, but the registered agent for an LLC has to be a physical address. So sometimes the registered agent of an LLC is the owner. You can set things up where that's not the case, but can an LLC have a P.O. box for doing business? Absolutely they can, and that can be the address that is otherwise disclosed under this request. So I hope that helps answer that question. Let's go on to our next printed question, which comes from Ariana Hamilton. This comes from our newsletter. What are my obligations regarding how cold the AC gets the unit? Tenant sent me a message that says something is wrong with the AC upstairs, gets above 80 every day and remains above 75 until at least midnight. Can we get someone to look at the units? The units are pretty new within the past 5 years. And we never had any complaints with the prior tenant who moved out in July. So I don't know what these numbers represent, and I don't know how hot it is outside, but typically there is a 20-degree rule of thumb. And so your AC should be able to cool the inside of your home down at least 20 degrees from how hot it is outside. Now, that being said, if it's 105 degrees outside and your unit is at 85, two things are going on here. Number one, man, is it hot outside. But if your unit is at 85, the people inside, while uncomfortable, are not at any risk of, heat stroke or heart attack. 85 while warm is not fatal. But again, these are extreme sorts of things. 105 and the lowest your AC gets is 85, but it holds at 85. Now, that also tells me there's some problem. They're either A, the unit isn't strong enough for the space, or B, the unit needs repair. So I don't know what's going on with the unit here. And it doesn't matter that it's only 5 years old. It could have been a crappy 5-year-old AC. But your best bet is to go out there and take a look for yourself. Don't take their word for it. Go out and confirm these numbers and take an AC person with you so that they can tell you, yeah, a tweak here or a tweak there will get the job done, or you've got a big problem with this unit because of X or Y or Z, and so these remedies must be employed, or we got to just get rid of the whole thing. I don't know what the case is, and so without more information, I can't really advise much more than that. So let's continue. Oh, well, we had some chats. Oh, James says, thank you. You are very welcome. Evaporative coolers have trouble cooling 20 degrees in humidity. Yeah. I clearly don't live in Houston. Yeah. And so, and again, what you want to make sure is that your unit is not keeping the home in a dangerous condition. If a home is up in the 90s and your AC is just cranking out as much as it can, now you're starting to creep up into danger, and even the average person is going to have a hard time once that house is in the 90s. Again, the 80s is warm, but it's probably not fatal. Once you start getting into the 90s and higher, you've got real problems, and you got to get it checked out. But if you're getting complaints like this, low 80s, mid 70s, it's worth it to go check it out just to make sure, because your tenant could be exaggerating, or it could be that the unit is beginning to show signs of wear and needs some servicing or replacement. So that's that. Let's move on. Julie Diaz writes, a tenant leased out of my commercial spaces 4 months ago, and now the tenant has informed me she'll be breaching the 3-year contract by moving out this weekend. What can I legally do to act fast before the weekend comes up? So there's a couple of things you can do, but you certainly can't grab the tenant and force the tenant to stay. You, however, might have a lien against the business personal property that is on the premises. Is it possible for you to seize that property and prevent the tenant from taking it off the property? Yes, that is mathematically possible. Before I would advise you to do this, I would make sure that your lease allows you to do this. What you have here may be what we refer to as anticipatory breach, where the tenant is telling you, look, I'm going to breach. No doubt about it, breach will occur. I don't know what the current status is. I see that they moved in 4 months ago. They signed a 3-year contract and now they want to move out. You know, if they're currently in breach, you might have a lockout remedy, and you can say, well, I'm changing the locks. I'm keeping all the stuff in here until you are prepared to cure this breach, particularly if it has to do with non-payment of rent. I don't know if any of those facts are here, but if in the middle of the night they just pack up and go, you're left to just your regular remedies under, contract litigation. Do you know where they are? Do they have the capacity to pay if you sued them for $1 gajillion or whatever amounts are subject to your lease? But other than that, you can't go and get a temporary restraining order forcing them to stay. Might you have liens that you could affect against their personal property, their business personal property? Yeah, but before you exercise any lien like that, unless you've done it before, I don't recommend you going and figuring that out for yourself the first time all alone. Talk to a real estate attorney, figure that out with them, and then you can proceed. All right, so here we have our last written question. I just watched your video, Tenant Scams. Great video. If you haven't seen it, I strongly recommend that you go check that out. But they just watched Tenant Scams. I learned that you can, or should, turn off all utilities before you hand over the keys. This brings up a question. If the tenant fails to turn on electricity or has it turned off for lack of payment and the pipes freeze, causing a lot of damage, can you hold them responsible? So there's a second question I'm going to get to in just a second. So if the tenant was negligent in the way they managed the property, and you can prove this negligence, you can always ascribe culpability to your tenant for damage to your property. Now, what they did specifically, I don't know. You're going to have some expert determine what caused the damage. And the reason I mention this is because your pipes, even if someone had been there, even if the heat had been on, even if all things had been normal, might have frozen and cracked anyway under the same weather conditions, no matter what had occurred. Now, I don't know if that's the case, right? But in severe enough storms, there ain't nothing you're going to do that's going to stop the storm from damaging your property. So if that was the case, I can't help, and say that the tenant was what we refer to as the proximate cause of the damage. It could have just been the storm was going to get you one way or another. But the question goes on. Can you hold them responsible? Side question. If they fail to drip faucets causing damage from frozen pipes, can you hold them responsible? Again, it's the same line of thinking. Can you prove that their failure to drip the pipe was what actually caused the damage, and not that drip, no drip, you were going to get damaged anyway? And so the burden is on you to prove that this thing made the difference. And I'll tell you that I've seen it go both ways in terms of expert testimony. Some people will say, yeah, it has a difference. Other people will say, no, it makes really no difference. And so the burden is on you to prove that what the tenant did or didn't do was what actually was the proximate cause and not something else. In this case, the weather. Yeah, and then she goes on to say, I know judges can be unpredictable. Well, and it's not just the judges, juries can also be unpredictable, and experts can say conflicting things. Your expert might say one thing, and their expert might say another, and it's going to come down to who the judge or jury find the most credible. And truth be told, it also comes down to the facts, because again, if the flood or the wind or the freeze were such that the damage was going to happen either way, then you really can't say that the problem was caused by the tenant. It was caused by the elements, and so it was an act of God. In which case, I'm hoping your insurance kicks in, and if we're going to say anything, it's don't put yourself in the hands of your tenant and their negligence or non-negligence, or your hands. Don't put your house in the hands of the jury or the judge or a long bout with litigation. Insurance is going to be your best bet. Make sure you are properly insured at all times so that if stuff like this does happen, you're covered. And let the insurance company fight over it. That's always, that's always my advice. I would prefer that the insurance go, and if they have a legitimate claim against your tenant, once they pay out your claim, they can go after that tenant all day long. But you want to make sure that you can move on with your landlording business and continue to thrive. So James adds, the tenant's heater turned off and he failed to notify me. The pipes froze, but luckily no damage. Well, that's good. That's good. And again, it's kind of a coin flip whether or not damage will actually result. Some people seem to believe that dripping faucets really has no real remedial effect. Others would say differently, but again, that's not my area of expertise. All I know is if I'm going to present a case like this, I got to have an expert that can demonstrate to a court or to a jury why precisely the thing the tenant did or didn't do was what caused that harm. So we are here at the end of another live stream. I hope you have enjoyed today's stream. For those of you who will be around next week, again, if you can, and I don't know how many are left, but this Friday we've got a live event in the Houston area. For those of you who are interested, I welcome you again to check that out. There's a link in the comments where you can find a little more information about it. I'll be there sharing with landlords how to properly issue notices, how to draft them. We're going to literally workshop multiple notices, how to deliver them, and how to use them the most effectively. If that's something that interests you, I would jump on this quickly because we're down to just the last few seats. If you can make that, great. I look forward to meeting you in person if that's something that you are available for. And so, again, we're here at the end. We will reconvene next Wednesday, and next Wednesday's topic is, let's see, what should landlords look for when screening potential new tenants? We're going to talk all about tenant screening next time, but for now, we're going to go ahead and close this down. I do want to thank everyone who joined. I look forward to seeing you next time. And if you're able to make that live event, I look forward to seeing you there. So until next time, landlords, happy leasing.